Hey, it's Chloe. Let's go into this drag ban. A lot of my friends in Houston have been asking me about this, and I think it's really important to get into the facts about this. Now, specifically, everyone's been like, well, it only goes over sexually oriented performances in front of a child. Now, that is very true. However, how we define a sexually oriented performance is relatively broad. Twerking could be considered it. Lap dance could be considering it, like moving your boobs up. Sexual gesticulation in general, breast pads and hip pads and stuff like that. Anything that could be considered in some sense erotic could be considered a sexually oriented performance. And it doesn't also specifically relates to kids that are specifically there. It could be something that could potentially, maybe, possibly be viewed by a child somehow. So if you're in a park, if you're on a street, it's behind glass windows, but you can look inside and you can see in a fenced off area, but you can see through the fence. That is problematic too, okay? And it also gives local municipalities the right to regulate sexually oriented performance. And because it's so broad, we could include dance troops in that, we could include concerts, we could include cheerleading in that, we could include a whole wide swath of things potentially. Now, it has specifically been called a drag ban. I should note that the Assistant Attorney General to Ken Paxton, not that Ken Paxton's a fan of the queer community, specifically says that it doesn't have to specifically be against drag, but the literal governor himself and Republicans overall in the state of Texas have explicitly called it a drag ban. So while yes, there is a narrow specific theoretical application of this, the legalese is so broad and so vague that it could be applied broadly to many people regardless of drag in general, regardless of the type of performance. So it does have that. I will say that the fine for a venue found in violation of this is $10,000, and if a performer, which doesn't have to be an employee, performer is also a vague term. Someone walks onto a raised platform and they start dancing, they could arguably say that's a performer. Again, the statute is so broad. Say if that performer is on the stage, they could get a Class A misdemeanor, and that's the same misdemeanor they give to people who lie in front of court, people who put people in the hospital, break into cars, people who lie in front of a jury, people who break restraining orders and stuff like that. Like, that is how they consider these performances. A lot of people have been canceling drag in general. That affects public events, that affects pride festivals, that affects community events, that affects nonprofits. There's like a general aura of I don't want to run potentially afoul of this generally vague law, which is why it was initially ruled unconstitutional in the first place. But the Fifth Circuit Court of Appeals that have banned the abortion pill, tried to strike down various aspects of the Affordable Care Act, said the Voting Rights Act doesn't apply in majority-minority districts, favor of the book ban. This is not a court that's exactly favorable. They haven't even ruled on the constitutionality of this bill. They have specifically just said that only one of the 5 plaintiffs have standing, and that is going back to a lower court under a process called remand. Meanwhile, the bill is free to go into effect. It's free to be vaguely considered. It's very problematic, and it's something that we should be aware of in terms of how it's applied. That's the real issue here. And they have very narrowly defined the parameters by which a proper case can be brought. We'll have more on that.